Let me remind everybody that we're going to be on YouTube. Okay.
I'm not going to sing.
Don't say too much. All right. Good morning, everybody. Court will start with the July 9th, 2020 docket, and this is County Court Law number 4, Hidalgo County. What we have here, let me see here, CL 20-1130, I'm sorry, CL 19-0647D, and that'll be Maria Delgadillo versus Jacob Brennan.
Correct.
All right, good morning. All right, and what do we have here, Mr. Ortiz?
Yes, Your Honor. I filed a motion to waive mediation. As the court knows, I've been a lawyer for a long time, and I've been a mediator for 27 years, and I've mediated a lot of cases with Allstate, but particularly this year, they just will not pay. They don't even get close to the medical bills. And this accident happened in January of 2019. We filed suit. We tried to settle prior to the lawsuit being filed. It was unsuccessful. And we've done discovery. It's set for trial. So I'm asking for a bench trial or a jury trial as soon as possible. And then as I know that the court has this rule about going to mediation, but I'm asking the court to dispense with mediation and setting up for a bench trial or jury trial ASAP.
All right, Ms. Regalado.
Your Honor, I understand why Mr. Ortiz has filed the motion. We always prefer to mediate, but we're okay. I mean, there are some reasons in this case in particular why it would be okay not to. So we leave it up to you. But as far as trial, we have demanded a jury trial, so we would be asking for that.
All right, court will hereby go ahead and waive mediation in this matter. So just submit an order, Mr. Ortiz.
I will. I think I have, but I'll double check.
Okay. And did you all submit a DCC already? Well, submit it along with the motion with the order to waive.
Okay.
All right.
Sounds good. Thank you, Judge.
That'll do it. You all take care.
Thank you, Judge.
Thank you. Care. Okay. Bye-bye.
Bye-bye.
Morning, Judge.
Good morning, everybody. Let me see. It could be this one here. Can do this. How about court will continue here with the July 9th, 2020 docket. How about CL 20-1132D, Delfino Flores versus Brock Services? Anybody on that one?
All right, that's me, Your Honor.
Good morning, Mr. Odom. There you are. Anybody here for Mr. Rafael de la Garza?
I heard from Mr. de la Garza's office this morning. He said he has another hearing, a contested hearing at 9 o'clock, and just asked if I would handle since it's an uncontested motion.
I'm sorry.
Uncontested motion.
It's an uncontested motion?
That's right.
Okay. All right, then the motions are granted and then submit an order. Okay, Mr. Odom?
Yes, sir.
All right, that'll do it. You're excused. Thank you, sir.
Okay. Thank you.
Thank you. Can you guys give me some more? This one? Okay. Right here. Oh, how about CL 19-4611D, Jacqueline Martinez and Noel Martinez versus Liberty Insurance?
Good morning, Your Honor.
Morning.
David Stevens on behalf of the defendant.
All right, Mr. David Stevens, I'm going to put your name here. And on the other side, will it be Mr. McAllen?
Yes, Your Honor. Willie McAllen. I'm here with Mr. Noe Martinez in my office.
Okay.
We're here. I'm here representing Mr. Martinez. We also have Mr. Eric Quiros.
Good morning, Your Honor. This is Eric Quiros from Pennebaker Law Firm on behalf of Mr. and Mrs. Martinez.
Oh, okay. Okay. Mr. Pennebaker's not around, right?
Not for this hearing, Your Honor.
We got Quiros and then we've got Mr. McAllen.
And Your Honor, if I may, I want to introduce Mr. Nigel Long and Mr. Al Berryhill. They are witnesses that I will be calling to testify.
Oh, okay.
Yes, sir.
All right. Very well. And I see him already, Mr. Nigel Long and Mr. Berryhill. Okay. All right. Let's see. Let's get it started here. What is it? A motion to set aside the default judgment?
Yes, Your Honor.
All right. Yes, sir. You may begin.
May I proceed? Thank you, Judge.
Yes, sir.
So this is Liberty Insurance Corporation's motion to set aside the default judgment. There was a default judgment that was taken in June, early June. This involves a dispute over insurance proceeds under a homeowner's policy and whether or not Liberty failed to pay enough to address storm damage. By way of background, Your Honor, this is a no answer default judgment. And so as the court, I'm sure, is aware, for the last 80 years, the guiding principles that have governed a court's evaluation on whether to set aside a no answer default judgment has been the Craddock versus Sunshine Bus case. That's been kind of an uninterrupted line of authority for the last 80 years. And so the factors of Craddock fit squarely within the facts of this case. And that basically, Your Honor, is that the failure to answer was a mistake, a human error, and not the result of conscious indifference. In other words, that in the case law is abundantly clear that to not meet that threshold, that means that you know you got served with an answer and you intentionally chose to ignore your obligations, fail to appear to defend yourself in the lawsuit. So I've had Mr. Nigel Long to testify. In addition to that, Your Honor, we have supplied what I believe to be an unrebutted affidavit or declaration from Mr. Long, who is with Liberty Insurance Corporation. He has been with the company for 12 years and been supervising extra contractual litigation for 5.5 years. And he's the gentleman who was responsible for the intake and processing of the lawsuit, as well as overseeing the strategy and defense of the litigation, including this case. And so Mr. Long's declaration in his testimony this morning will clearly show that it was a human error. The only time in 5.5 years that this has occurred on his watch where there was a mistake, where he received the notice and just simply failed to process and push it forward to counsel to represent or to answer on behalf of Liberty. Secondly, Your Honor, the second prong of Craddock is that there's a meritorious defense. And with regard to that, we don't have to prove our case. It's not like we are needing to prove by a preponderance of the evidence or anything of that nature. But we just have to set up that there are facts that show that there's a meritorious defense. And with regard to that, we've attached the insurance policy and other evidence to the motion for new trial, which sets forth the dispute. And basically, in a nutshell, and I know this honorable court has had occasion to have windhill litigation over the years and is familiar with the dispute, but basically the issue is the cause and extent of storm damage to a property. And oftentimes there will be other factors that may have contributed to the damage, whether it's wear and tear, construction defects, and some things are not covered and some things are covered. And so Liberty in this instance investigated the claim that was made for storm damage, estimated to pay for that damage. And now there's a dispute over the extent of that damage and the cost of repair. So Mr. Berryhill has supplied an affidavit, again, I believe it's unrebutted evidence, that there are other issues that have caused or contributed to the damage that are unrelated to the storm, so that there's a meritorious defense. And so we've set that prong, I know, Judge, that's unrebutted, and so we meet the second criteria. The third and last criteria under Craddock is that there's no injury to the plaintiff for if the court were to grant the motion. And by that, the Supreme Court has addressed that prong as well over the years, and that is simply, is there going to be a loss of evidence? Is there are witnesses not going to be present? And that's just not the case. And again, it's unrebutted, that presumption, and certainly the facts bear out that the property is still there. Mr. Martinez is still there. The experts, can be, or they can get other experts to present their case at trial. And we're announcing that we're ready to proceed, answer in this case, and proceed with the case to trial. Now, one of the things I want to mention, and I'm glad Mr. McCallum is here, because I've known Willie for, gosh, it's going on 15 years, Your Honor. We've had, with his uncle, David Garcia, may he rest in peace, that we've had hundreds of cases together, starting with the mold litigation in mid-2000s, Hurricane Dolly, the 2012 Hidalgo County storms, 2015 storms, and more recently, there was more current storms. So Willie and I go way back, and I consider him a friend, even if he's an adversary. And I was surprised and honestly disappointed, Your Honor, when this default judgment was taken. And here's why. There's two reasons. One, the Texas Lawyers Creed, which governs the conduct, ethical conduct of attorneys, says, I will not take advantage by causing any default or dismissal to be rendered when I know the identity of an opposing counsel without first inquiring about that counsel's intention to proceed. And in this instance, Your Honor, prior to the default judgment being taken in June of 2020, we have represented Liberty in this dispute because Mr. McCallum or Mr. Pennebaker had issued or served a DTPA demand letter, an insurance code notice letter, putting Liberty on notice that they have issues with the insurance claim. And so within days of receipt of that notice, Liberty contacted me to represent it in the dispute. I then contacted Mr. Pennebaker's office. We set an inspection so we could promptly look at and try to resolve this dispute. We then got out there with Mr. Berryhill within about 6 weeks of that insurance code notice letter to inspect the property, to evaluate what's our potential exposure, what's going on here. We had their estimate. Let's look at the house. And so we did that very promptly. We responded to the DTPA. There's actually, and that's, again, this is appended to our motion for new trial. So we responded to their DTPA letter in June of 2019. Suit was filed on August 29th, 2019. And it's undisputed that Liberty did not answer. But after the lawsuit was filed, we proceeded to work and try to negotiate a resolution to this dispute, including setting a mediation with mediator Gil Perales, in which his mediation confirmation notes on the ray line that it's a pre-suit mediation. And so we go to mediation, and that was held on November 5th, 2019 at Gil's office. And unfortunately, we were not able to resolve the dispute at that time. And so Mr. McCallum knew that Liberty was represented, knew that Liberty was defending its position in this case, knew that I was representing Liberty Mutual, and presumably Mr. McCallum, Mr. Pennebaker, and Mr. Quiros were aware of their responsibilities, I would say, under the Texas Insurance Creed, the Texas Lawyers Creed. So that's, Your Honor, by way of background on the dispute. I want to emphasize just a few points. And again, this is supported by the affidavits and declarations that are attached to the motion that are unrebutted. But in terms of the first prong, as I mentioned, Mr. Long will testify, and his declaration states that what happened was that it was a mistake. That Liberty has a very robust process and set of procedures in place to intake, process, and defend itself in litigation in Texas and across the country. Obviously, it's an insurance company that's fundamentally important to its business. And it has a very stringent, robust policy and procedures in place. Just in this case, the only time in the 5.5 years Mr. Long was overseeing litigation in Texas, he made an error. Plain and simple human error. He made a mistake. But
Okay.
Go ahead. I'm sorry, Judge.
I'm sorry. So we're going to put some testimony for Mr. Long here?
Yes, Judge.
We can do that. Now, you want to do it now?
Sure. And what, Judge, what's the procedure?
Procedure,
Now that we're in Zoom world, how would you prefer to do this?
Okay, so you gave us a small introduction. So now, Mr. Quiroz and Mr. McClellan, you want to respond a little bit and then we hear some evidence? Is that what you want to? Or should we just hear Mr. Long right now?
I would welcome Mr. McClellan's response.
Your Honor, yes.
Well, okay.
In the
Go ahead.
In the what's a little getting lost in the arguments here is that we filed this lawsuit back in August. I during the time that we had the mediation was under the assumption that everyone knew there was a lawsuit pending. We waited to not proceed or move forward with the lawsuit until after the mediation. Then again, November, January, February, March, April, May, the whole pandemic happened. The Supreme Court put a stay on all the any kind of defaults. And then we, during that time, there still wasn't an answer filed. We filed our motion back in, I think, March for default. Still nothing got filed. Mr. Martinez is, what's getting lost in the sauce is that Mr. Martinez here he's been paying his insurance policy. He's got a family there that's been having to live with his house in this condition. He also, some members of his family are immunocompromised. So it's something that is affecting his life very, very significantly. And I understand that David and I are friends and that we've known each other for a long time, but I think I was more than fair in affording an opportunity to file a response for over almost a year. I also have some obligations to my client at the same time. I need to move his case forward. We felt that there was, that it had been just sitting there getting stale. So we had to find a way to get Liberty's attention. And unfortunately, it was the only way that I could see that we could do it. But now we're here today. We understand that it's got everyone's attention, including Mr. Stevens and everyone at Liberty. And what we're hoping is that we can come to some kind of a resolution. We don't have to go through a ton of further litigation and hearings and anything like that. Maybe what I was going to suggest to the court is if the court could hold on to this and maybe send us to mediation so that we could not have to do any, testimony or anything of that nature, because we also have incurred expenses of attorney's fees and in filing default and moving forward with this procedure. Unfortunately, that's a cost that's paid by my client. And that's just something that I want to take. I want to say that I don't want to forget him and his family. That's, ultimately they're the ones, and Liberty has some obligations to them. I don't want them to get forgotten in kind of the procedural issues that are happening here, because ultimately they're the ones that are suffering here. And I just want them to be made whole. And so that's really my argument. I hadn't seen an addendum to it, so I and I understand he's here to testify, but I didn't, other than the initial motion, I hadn't seen any affidavits where there, the whole thing with the email that wasn't sent. So I'm interested to kind of hear what happened there, just so I can explain to my client.
Okay. So basically what you're saying is hold on to this. I mean, pass this hearing for another 30 days, but order you guys to mediate. Is that what you're saying?
That's what I was hoping. Maybe we could resolve this case without having to push it any further, incur further attorney's fees on our part, on the insurance's part. I mean, and if the court were to order it, we would go in good faith to try and resolve the case.
As long as the court still has jurisdiction, right? Assuming it'll still have jurisdiction.
Yeah, I mean, I think you have jurisdiction for 105 days from the signing. David, would you agree?
75, 85, 75 or 105?
Right. Yes, Judge. You have jurisdiction over this for an additional period of time. I would have to look at the rule book.
Okay.
I guess a couple of things I would like to address with Mr. McCallum. When he said he had no choice but to file a default, he had a choice. And the Texas Lawyers Creed tells him what to do. And he picks up the phone, and this is pretty common, and it's especially common when you have developed a relationship with your adversary over the years. And so it is particularly common to say, hey, you guys haven't answered, what's going on? And then we're like, check it out, holy cow. Yeah, thanks for the heads up. And so, that's done for two reasons. One, the Texas Lawyers Creed says to do that. Secondly, because I think the CRADIC standards are such that if it's a mistake, then the default judgment gets set aside. They have to show, this conscious indifference and things like that. And again, the evidence and the declarations that are presented with our motion are unrebutted, and they clearly establish that. And I did tell Mr. McCallum before the hearing that I said, look, I'm happy to negotiate. And he knows we've had hundreds of these cases, and we've resolved them by and large. And so that's not an issue, Judge. What I did tell him, though, was that we first needed to resolve this dispute. I didn't want this to be any leverage over the negotiations. I want the negotiations to be truly based on the merits of the dispute. And we have historically resolved those cases. And that's what I would suggest today, that because we have presented our case. I have brought our witnesses to corroborate what was already before the court in the affidavits and declaration. And I would point out one other thing that where we filed a couple of days ago, Your Honor, where really the basis for their motion, their default judgment, relies upon an estimator, a construction expert of sorts, that went out there and evaluated the property. And we filed an objection to that affidavit because this is a flat roof. It's a construction material called TPO. It's kind of that rubber material. And so it's a two flat roof, 2-story house. Mr. Salinas, in his declaration or his affidavits, says at length that the damage he observed is related to lifted shingles, broken shingles, missing shingles, all manner of damage to shingles, which don't exist at this property. And we provided a couple of images of the property that were taken by a drone survey, and which clearly show the type of roof, and it's in our objection to Mr. Salinas's affidavit. So, I mean, the basis for the default judgment is in error. But on top of that, regardless of that, we presented evidence to show that it's a mistake and not conscious indifference, that there's a meritorious defense, and that there's no injury to Mr. Martinez by the court's granting the default judgment. We're ready to proceed. We're ready to proceed to trial. And I told, and I will honor my statement to Mr. McCallum, that we're more than willing to go back to another mediation. But I have our folks here today. We presented our evidence, and I respectfully would request the court to address and rule on the motion. In addition to sending us to mediation, which is fine.
And I would disagree that there wouldn't be any injury to our client, Your Honor. Like I said, this is a special case because it's not just that there's damage to the property, it's that there's a family living in the situation, and part of those people are in dire need of making repairs to that property, and he's unable to do that without
Let me hear Mr. Long, and then I guess Mr. Berryhill, and hopefully we can do it quickly.
Yes, sir.
And we'll go from there. Mr. Long, good morning, sir. Thank you for your attention here and for standing by. Please raise your right hand. You swear
morning, Your Honor.
Good morning. You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you may put your hand down. Mr. Stevens, you may begin.
Thank you, Judge.
Yes.
Good morning, Mr. Long. Can you introduce yourself to the court?
Yes, my name is Nigel W. Long.
And Mr. Long, where do you reside?
In Braintree, Massachusetts, just outside of Boston.
All right. And can you give the court a brief background on your education and what you do for a living?
Sure. I graduated from San Diego State with a Bachelor of Arts degree in political science, a Bachelor of Science degree in psychology, minoring in sociology. I then attended Western New England University Law School, graduating in 1998. My career has been as a trial lawyer in Boston. Up until the last 5.5 years, I've worked in law firms as well as at Liberty Mutual. And about 5.5 years ago, I went corporate counsel at Liberty Mutual when I took over the role that brings us here today as corporate counsel overseeing extra contractual and bad faith litigation against the company.
Thank you. And what are some of your job responsibilities as in your position as corporate counsel at Liberty Insurance Corporation?
So part of them is to oversee and direct extra contractual litigation against the company. And by that means when we become aware of litigation or a claim that does involve either bad faith or extra contractual damages, then it is my job to retain counsel, such as yourself, in the particular jurisdiction, formulate a litigation strategy or a legal strategy on how we're going to handle this to defend the corporation as well as to get the matter to resolution.
And
so handle it from the very beginning when it comes in all the way through to the conclusion, whether it be trial, mediation, arbitration, or settlement, or dismissal, whatever it may be.
All right, and I believe you said as part of your job responsibilities, you process new lawsuits that come in or legal documents that come into the company.
That's correct.
All right, describe the procedure that Liberty Insurance Corporation has to ensure that it receives notice and answers whatever would be appropriate under the circumstances, including a case like this with a petition or lawsuit that's filed against the company.
Sure. So our registered agent for Texas is CSC. And so the matter gets served, for example, by Mr. McAllen or Mr. Pennebaker. They serve it on CSC. CSC then sends my organization a series of alerts letting us know that a new matter has been filed, and that could come in the form of a DTPA has been filed as it was in 2019, or if litigation, a lawsuit is filed, a petition is served, then we get that alert, and we also get a number of emails corresponding with those alerts in CSC.
Okay, and in this instance, can you describe what sort of notification Liberty Insurance Corporation received about this dispute initially, and then subsequently the lawsuit?
Sure. I want to say it was April of 2019, received an alert in CSC and the corresponding emails. And upon receipt of that, identified what the issues were, identified what type of matter it was, and then went and selected counsel, your firm, to attend to that. And so then I sent your firm an email asking you to clear conflicts and also notifying the appropriate stakeholders internally of the matter so that we could all, within a few weeks, get together and get aligned on what our strategy moving forward would be.
Okay. And then with respect to the lawsuit, the petition that was filed in this case, that is the reason why we're here today, can you let the court know your understanding of when that lawsuit came in and how it came about that it did not get forwarded to counsel to address?
Sure. So similar to the DTPA that came in April of 2019, I saw the alert and the email that came in with regard to the lawsuit. I remember typing the email to you saying this is a lawsuit and follow-up to the earlier DTPA. And my internal system and the internal systems within the company are that a number of admins, paralegals, and lawyers receive the same alerts. So it's a redundant system. The way I've always handled it is once these things come in, I tell everybody, I've got it. Don't worry about it. I'll take care of it. And that's what I've always done because we've always had the direct email or direct telephone conversation with all of the council. And then I set up a redundant system within my own system, which is I keep a specific email alert on the matter in my inbox. And that's my go-to sign that I know without having to go through any other system, that if that email is still in there, when I go to look for it to make sure everything has been done, if that email is in there with a copy, I blind copy myself on the referrals out to outside counsel. So if I see both of those, then I know I'm still waiting on counsel to let me know, okay, I've got it. So on this particular time, I went in and looked and I did not see either the alert email, nor my email referring it to you, nor your email saying you've got it. So I took that to mean, okay, so I've already received them and David's got it because they were not in there. My system is, if they're still in my inbox, then I have not yet received your confirmation email. If they're no longer in my inbox, I've received your confirmation email and it's gone out. And that was my understanding when I looked at it contemporaneously with everything. And I may be getting ahead, but I did not become aware of the default until it entered, I believe, in June. And just to clarify something, the last thing that we got prior to the default was the lawsuit in, I want to say, September. So we never got served a motion for default. So I was never aware that a motion for default was ever filed. The last thing I got was notice of the litigation, which I just discussed. And then the next thing I got was the entry of the default.
With regard to the oversight, Mr. Long, was that just simply a mistake on your part?
I accept full responsibility for it. I'm too seasoned to allow that to happen. And as I admitted, I was shocked that it did happen on my watch, and it was completely an error on my part.
Your Honor, I'll pass the witness, and if the court has any questions of Mr. Long, I'll be happy to entertain that.
All right, thank you, sir. Mr. Quiroz, were you gonna?
Eric, you're muted.
You're on mute.
You need to unmute, Mr. Quiroz.
I apologize.
Okay.
I don't believe we have any questions for Mr. Long. Thank you, Mr. Long.
All right, thank you, sir. Mr. McKellen?
Mr. Long, in the response or in the motion, I did see that there was a mention that there was an email that was sent or that was typed out and never sent. Would you happen to have a copy of that email, or maybe in your drafts area that we could provide to the court to show?
No.
Is there subsequent to receiving the lawsuit? Did you have any conversations with Mr. Stevens' office saying, hey, what's going on with that lawsuit, or anything of that nature?
No.
When the mediation occurred, were you involved in any of the decision makings when it came to the authorization of authority or anything of that nature?
Off the top of my head, I do not recall. I don't recall if this was something that was, I believe it was purely policy money, so I would not have been involved in those.
Okay.
And if I may, and Judge, and I'm
yes,
Willie, but when a case goes to mediation, there is a litigation adjuster, and that's who I introduced. She was present by phone. It was Tara Lloyd, and Willie, that was who was present at Gail's office that day for the mediation.
okay.
And who is that litigation adjuster?
Tara Lloyd.
Okay. And back to Mr. Long, has there been any other, or was there any conversations regarding the lawsuit? Once you sent off that email, or you thought you sent out that email, is that the extent of, you no longer have anything to do with it? It's passed on to Mr. Stevens' office, or?
Well, I knew that I don't remember if it was exactly at that time, Mr. McKellen, where we had been discussing mediation. So it all kind of folded naturally into, there was no real reason for me to actually be giving a lot of concern to that, because I knew we were discussing going to mediation. So it never occurred to me to have to say to Mr. Stevens, and it probably didn't, I have no specific memory of that, even of the litigation crossing my mind again after the initial alert and email. But I did know that we were working to get to resolution toward mediation. I want to say about a month later, a month and a half later. I don't know if it was October or November of 19.
Yeah.
And then after the mediation, I'm just, for my client's sake, so I can explain it to him. After mediation occurs, is there any, the return to discussing, hey, what are, because I'm assuming you were aware there's a lawsuit. So when you discussed the case with Mr. Stevens, was there any discussions of, hey, we didn't settle at mediation? What's the next step in this litigation process to see if someone was made aware that this case was already in litigation? And because my client's been, is waiting for that.
So just to be clear, I want to make, I need to make sure we're protecting attorney-client privileges. And I know Mr. McCallum is not trying to get into strategic discussions or anything like that.
No, just pertaining to this motion, I'm trying to ascertain if, because they're saying that notice was never given. And so I want to know if, because the mediation happened, we've had several different things, the DTPA demand, the serving of the lawsuit, the mediation, and then almost 6 months passed after that. And I know Liberty is claiming that notice was never given through email, but I'm asking if there was any discussions to say, hey, how's that lawsuit going? Hey, we didn't mediate the case, or we didn't settle it at mediation. What's the next step? There's a lawsuit pending. Mr. Long is aware there's a lawsuit. His discussions, not regarding any trial issues, just notice whether there was discussions in notification. Like I've spoken to Mr. Martinez, there's a lawsuit pending. There hasn't been an answer filed. The mediation, we can circle back and try to resolve this case. That kind of notification where you're told, just verbal discussions, has anything of that nature occurred subsequent to the mediation?
No, and I want to be very clear about this. So when in any litigation, whenever these things come in and I forward them off to counsel, whether it's this case or any other case, then I rely on them to do the necessary things. So when I'm looking at this case with Mr. Martinez, your client, I'm not specifically thinking about what are all the things that have happened in this matter specifically, if you understand what I'm saying. So that never even crossed my mind, just like litigation didn't cross my mind, and it probably should have, quite frankly. And that's why I'm accepting the responsibility for it. Because of me, Mr. Stevens never received notice. Because of me, we are now sitting here in this court talking about a default. And that was because of my oversights.
And if I may jump in, Willie, as I mentioned, Your Honor, there was the person that was responsible for negotiating and attended mediation was with Ms. Tara Lloyd.
Okay.
Without revealing the content of the discussions, Ms. Lloyd and I have been in communication on this matter, and most recently, I think it was in April, and where we were discussing what can we do. I mean, this case has been pending. Can we file or serve a 167 offer? Of course, an offer of settlement that's available under the Texas Rules of Civil Procedure. And then we recognize, well, that we can't because there's not a lawsuit pending. So that's a discussion we had. We were just unaware that the lawsuit had been filed.
Okay.
And what we've established with Mr. Long is it was a mistake. It was a human error. There's a very robust process in place to make sure that these lawsuits get forwarded to outside counsel so that the company can be defended. And it just didn't happen. It was oversight in this case.
All right.
And Your Honor, if I may just address that last point very briefly.
Yes,
I
sir.
can assure you there was no intent on my part in any way, shape, or form of this. I've had several cases with Mr. Pennebaker's office, and I think even Mr. Pennebaker's office would agree this has never happened before. There was definitely no intent on my part. This was just a human error for which I accept the responsibility.
Okay. All right, Mr. McCallum, anything else, sir?
All right, I just would ask that the court send us the mediation, because Mr. Martinez is really, this is not the run-of-the-mill case where there's a client that has some damage to his home and we're just waiting to see if we can make the repairs.
Okay.
With all this going on, his family is staying at home, and that home every day or every rainstorm is being submitted to additional damage, and
Okay.
that affects their health.
Okay, are we gonna hear some more? Are we gonna hear some more testimony from Mr. Berryhill?
Yes, Judge. May I present?
You want to put him on quickly?
Yes, we'll do it. Yes, we'll do it quickly.
Okay. All right. Before my battery runs out.
Yes, sir.
All right, Mr. Berryhill, good morning, sir.
Good morning.
How you doing, sir? Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You may put your hand down. Mr. Stevens, you may proceed.
All right. And good morning, Mr. Berryhill.
Good morning.
As the court had noted, we don't have a lot of time this morning, but I do want to I wanted to put you on, and I appreciate your attendance this morning. Can you briefly tell the court about your professional background?
Yes, Your Honor, my name's Al Berryhill, and I'm the owner of Crosspoint Construction. Crosspoint is primarily a restoration contractor. We do roofing work. We do a variety of remodeling and restoration activities. And I also have, about 18 years in water damage restoration, specifically going back to mold remediation in the early 2000s.
All right, and Mr. Berryhill, with regard to the dispute with Mr. Martinez, did you have an opportunity to inspect Mr. Martinez's property?
Yes, I inspected on May 14th, 2019.
And at that inspection, did you have the competing estimate, the estimate that was provided by Mr. McCallan's office from Oscar Salinas with his estimate of damages?
Yes, I had an estimate from Liberty Mutual, estimate and photographs from, well, not from Mr. Salinas didn't have photographs, but I had Mr. Salinas's estimate, and also had a report from American Leak Detection. Okay,
and so you were aware that this was a dispute under the insurance policy, and the determination or the issues that were in contention were the cause and extent of damage from the storm?
Yes.
All right, and so you also were aware that you're looking for storm damage, but there are also often other contributing factors that may cause damage or contribute to damage, either to the exterior or the interior of a property. And so you're evaluating that as well. Is that correct?
That's correct.
All right. And so during your inspection, what did you do? If you can briefly walk the court through what you did as part of your inspection.
Sure. I looked at, Your Honor, it's a two-story house with a contemporary style, like a staggered box style. And so I looked at all four sides of the house, which was primarily stucco, for evidence of damage or just a condition of the exterior. I also looked at, there's two levels of roof, a front lower level, second floor upper level, and then another lower level over the garage. I looked at those all three of the roof systems, and it has parapet walls, so a perimeter wall around it. And I looked at those parapets. I also used I commissioned a drone survey, which could give a better view of what the upper walls look like from the outside that you can't get to without a drone. And then I also looked at not only the area in the living room, which was where the moist drywall was, but also all of the other rooms in the house. The Martinez were there and provided me access to the entire house.
Okay, and as part of your investigation, did you come to a determination as to whether there was wind or hail damage to the TPO flat roof system?
Yes.
What did you determine?
I didn't see any evidence of wind or hail damage to the TPO. I mean, TPO is very resistant to wind and hail, and there was no evidence of ballooning or blistering that might indicate wind. There was no part of the TPO that was detached, and I didn't see anything that looked like hail either on the TPO or the parapets or parapet cap flashings.
And with regard to the moist interior drywall that you mentioned, did you come to a determination as to how that moisture or that water penetrated the exterior?
I was able to resolve it down to, I think, one of two or three possibilities. Your Honor, when you look at the wall, there's no water staining on it per se. It's if you take a moisture detector and put it on the wall, you see high moisture in a small area of this two-story living room. And you move away from that on either direction, you don't detect moisture. But it's not what you would expect, perhaps, where there was a discolored, at least at the time I was there, a discolored water stain or something that would say, here is exactly what I'm looking for. So I had to identify the parameters of the high moisture using a moisture meter, which I had with me. And there were really two things that I noticed in the proximity of the high moisture wall. And one was that there were some unsealed overlaps in the metal parapet cap that were above. There was a seam above that location. That could be that seam needs to be periodically maintained with caulk or some sealant so that it doesn't leak. And then there was another location where the front lower parapet was it terminated into a wall, and there was a gap at the termination between the metal parapet cap and the stucco wall. And at the time Liberty Mutual took their photographs, that gap was open, and you could see a clear entry point. At the time I was out there, someone had applied another bead of caulk along that line. So it was in better shape when I was out there. There'd been some maintenance done. Okay. And then the third possibility, which is something, there was a small area of discoloration on the exterior, not like an impact mark, but just almost a texture change in the exterior stucco behind that part of the wall. And it's possible that wall had been repaired sometime between the house being constructed and the time I was out there. It was subtle and you couldn't see specific damage, but it's possible that the wall has some breach in it.
All right, a couple of questions briefly. What was the condition that you were describing? Was that the result of a wind hail cause of loss?
No, there was no openings or no indentations in the roof or the wall systems.
In the three possible scenarios that you described, is that due to faulty or defective construction or just deferred maintenance?
Deferred maintenance. It was probably installed reasonably. I couldn't get in the wall to see whether the flashing was correct, but it's most likely it's maintenance.
And is that common with the flat roof system?
It is. Particularly with parapets, you have to maintain them or they'll eventually leak.
Right. So, Your Honor, in the interest of time, I would also refer the court to the affidavit of Mr. Berryhill that's attached to our motion, and there's some photographs within the motion as well as additional explanation from Mr. Berryhill to set up the meritorious defense that this is a breach of contract action, and what's caused by wind, hail versus what may be caused by other.
Mr. McCallum, any questions?
We have our estimate and our expert, Your Honor. We don't need to cross.
All right, then. Okay, what the court's going to do here is, first of all, take judicial notice of the entire file hearing, cause number CL 1946-11D in the case of Jacqueline Martinez and Noe Martinez versus Liberty Insurance Corporation. Court will go ahead and admit into evidence all exhibits being offered, including any case law if you have any. And I'll take this matter into advisement and go ahead and make a ruling hopefully real soon. Submit your proposed orders, please, okay?
Yes, Your Honor.
And to all the witnesses, thank you very much for your testimony and for your participation. You all may be excused.
Thank you, Your Honor. Pleasure to be in your court, sir.
Thank you very much. Yes.